Good morning to you all, and welcome to the ENS Africa webinar, where Willem Leroux and Celeste Coles will explain various provisions of South Africa's Draft Mine Health and Safety Amendment Bill. The bill was published on 15 June 2022, inviting interested and affected parties to submit written representations on the bill to the Minister of Mineral Resources and Energy on or before 29 July 2022. And we are currently getting very close to this particular deadline date. In this regard, we are honored to hear from Willem today. Willem is an executive consultant in ENS Africa's Mine and Occupational Health and Safety Department. Willem was the lead lawyer advising the Chamber of Mines, now the Minerals Council South Africa, during the Leon Commission of Inquiry into Safety and Health in the mining industry. For many years, Willem has also been advising and representing employers' organizations and various prominent mining groups. Willem is also the author of Mine Health and Safety Law, an authoritative loose-leaf publication published by LexisNexis. Celeste is a director in ENS Africa's Mine and Occupational Health and Safety Department. She is an experienced lawyer and has over a number of years been involved in various prominent matters in the mining industry. My name is Pieter Kulain, and I'm the head of the ENS Africa's Mine and Occupational Health and Safety Department. I will facilitate today's webinar and request you to participate in an interactive manner. So please pose your questions at any stage during the webinar under the Q&A function. Willem and Celeste will aim to deal with such questions during their presentations, and I will also pose some of these questions to them where required. We aim to conclude the webinar by approximately 10:30. And now, without any further delay, let me start today's webinar by posing the following question to Willem, our first presenter. Willem, it is clear that the bill contains a number of far-reaching provisions which will have a great effect on the mining industry. What is the historical background to the bill, and why have these changes been proposed?
Yeah, thank you, Peter. I will deal not only with the direct and the immediate history of the bill, but also with some background. Now, way back, the 1956 Mines and Works Act regulated mine health and safety, and then eventually the Minerals Act was promulgated in 91, but that dealt very little with mine health and safety. It made provision for the holding of inquiries and certain other matters, but that's where it stopped. It didn't spell out the health and safety obligations of the employer, for example. That's why the Leon Commission was established in 1994, and that was chaired by Judge Leon and certain other experts. They delivered the report in 94, 95, and then in 95, the drafting of the legislation started, the Mine Health and Safety Act. That was then published in 1996. But before it commenced, an Amendment Act was promulgated in 1997. The reason for that was the following. First of all, in terms of the Mine Health and Safety Act as it stood originally, the obligations for health and safety rested with the manager to a very great extent. It was spelled out like that in the Act, and then also the owner. But which was very objectionable at the time was the reversal of onus that was implemented or promulgated or stipulated in the Mine Health and Safety Act. In other words, in many instances, the employer or owner had to disprove liability That was contrary to the Leon Commission report and their recommendations. And so the employer bodies and also certain of the trade unions objected against this. And then there were negotiations with the Department of Minerals and Energy at the time. And then the following was agreed eventually with the department. And that is that the Mine Health and Safety Act would be changed in that the obligations for health and safety would be placed primarily on the manager, on the employer. And the employer, as you know, is defined as the owner, et cetera, et cetera. And then further, that the reversal of owners would be scrapped, and then that a system of administrative fines would be introduced. So that is where the administrative fines came from. So then in 1997, everything was implemented. Then in 2005, the Department of Labor, not the Department of Minerals and Energy, they prepared a National Occupational Health and Safety Bill, which was intended to merge the health and safety law of the mines, applicable to the mines, and those applicable to industries outside the mines. But that was not even published for comment, and it died a natural death. Then after 2005 came 2008. And that in 2008, the Amendment Act 74 of 2008 was published. And that introduced corporate manslaughter and strict liability. And you will see that today in Section 86A, we will again deal with corporate manslaughter. But the corporate manslaughter provisions were not implemented. There were negotiations between the Chamber of Mines, the department, and the various representative trade unions, and eventually it was decided to request the president not to implement the section relating to manslaughter. So that was held back. Thereafter, after 2008 came 2013. A draft Mine Health and Safety Bill was published, and that is the time when the thinking about this 10% of turnover as a penalty was introduced. But that we opposed again, and it didn't go through, and it wasn't enacted. And now we've arrived at the Mine Health and Safety Amendment Bill that was published in June this year for comment. So that's the background of it. But you will see also certain other sections in the previous bills. Those sections, in fact, appeared in the previous bills, and now they repeat it. And it seems to us that the drafters have forgotten the objections against those sections. But I will here and there deal with the important ones. I see somebody's raising his hand, Peter. I don't know whether we should deal with that.
Well, I propose that we can deal with it, or the person can post the question in either the chat box or in the Q&A box. But Romain, you can just indicate if we can put that person on speaker that's raising his or her hand.
I've got no difficulty to deal with questions in the meanwhile. If it's too interrupted, then we will move it to the end. But it's a matter which is relevant now, we can deal with it. Okay, it seems to me that perhaps the hand on my screen is a fictitious hand. So let's carry on. So now over to Celeste.
Thank you, Willem. So I think the chats and the comments were that the slides weren't moving. So just for all panelists to be on the same page, The slides, we've only dealt with the actual amendments in 2022, and this introduction by Willem was just to give a little bit of a background to the development of this amendment bill. And Willem's now dealt as well with the basis of the amendment bill, so I'm going to kick straight into the interest inside of it, if I can get this thing to move. There we go. So I'm going to start with the proposed amendments to Section 2 of the Mine Health and Safety Act. And I want to straight away link it to a proposed amendment to a definition. And that would be the definition of an employee. And if one notes in the amendment bill, what they have done is to propose an amendment to the term employee. So employee currently defined as being anybody employed at or working at a mine. They have now proposed, or the legislature has proposed, that an employee means any person who is employed by the employer or owner of a mine, or who is working at a mine, and who is working at a mine. Effectively, what that proposed amendment has done is resulted in the exclusion of employees of a contractor company, for example, being included in the definition of an employee. So the current definition includes contractor employees. If this amendment goes through, then it would exclude contractor employees. And then that amended definition will have to then be interpreted in line with the proposed amendments in terms of Section 2 and going forward in the Act. So, Sonia, if you can just help me and get back. Oh, there we are. Okay. So Section 2(1)(d), the proposed amendment is to remove the reference to a body corporate to company, and that's no problem with that proposed amendment. It makes sense to change that to a company. But here is the relevance of the change in the definition of 50 employees, because that now limits the number of employees to persons who are employed by the employer or the owner and who are working at the mine. So that would be the basis of the calculation of the 50 employees. And the same comment and relevance to the proposed amendments references in with the new proposed insertion of Section 2(b) relating to the appointment of a chief executive officer. And for the purpose of today's seminar, I'm going to draw your attention specifically to the proposed amendments 2(b)(4), which says that the chief executive officer must be responsible for the health and safety of employees and persons who are not employees, but who may be directly affected by the activities at the mines. So that in itself indicates that contractor employees will not be the responsibility of the chief executive officer, but he would then hold an obligation towards said persons as people that are not employees, but who are directly affected by the activities at the mine. And obviously that then relates to the fact that the chief executive officer and the employer does not have health and safety obligations towards non-employees in terms of the application of sections 2 to 15, for example, of the Mine Health and Safety Act. But his duty of care, most probably his or her duties of care, would be interpreted in terms of the common law duty of care towards the health and safety of employees, and that results and that implies reasonable health and safety for said persons. So there seems to be a bit of a disparity between the intention perhaps of changing the definition and the ultimate effects of the proposed amendment to this definition and the long-term effects to the application of health and safety at a mining operation. Those are the portions that I just wanted to deal with, particularly with Section 2, the proposed amendments to Section 2. Willem will now deal with the proposed amendments to Section 10 of the Mine Health and Safety Act, and that relates to training. Thanks, Willem.
Thank you. Now, the section 10 deals with training, and that says at the moment that as far as reasonably practicable, the employer must ensure that every employee is properly trained, etc., etc. Now, the words "as far as reasonably practicable" were inserted right in the beginning in 1997. Then in 2013, in the draft Mine Health and Safety Bill, there it was proposed to delete the words "as far as reasonably practicable," and we opposed that with success. And then that was dropped. But now the department has come back and have again proposed that those words be deleted, and that the obligation to provide training now be an absolute one, in that it must provide, according to the amendment, that every employer must ensure that every employee is properly trained, the nature of which training must be determined by the employer, having regard to the needs of the work to be performed. Now, that's very, with all due respect to the department, very short-sighted, because as soon as we use the words "as far as reasonably practicable," then we refer back to the definition of reasonable practicability. And that, as you know, refers to a number of issues that must be taken into account when you deal with a particular topic. Amongst others, the hazards and the risks involved in the particular case, the cost involved, and so forth and so forth. That's defined in section 102. So as a result of the reliance on the definition of reasonable practicability, which is the health and safety criterion in the Mine Health and Safety Act, you get a dynamic approach in that people must take into account other practices applied generally by other mining companies, other experts in the field, what the statutory bodies, what they recommend, and so forth. And it is a situation where the standard can change from time to time as you acquire more knowledge. And you as employer must keep track of these changes. So that is why it is an excellent concept to make it dynamic and adaptable from time to time. Now, if that is deleted, we will lose that approach. And it's not clear what exactly the approach now should be. Now, all it says is that the employer must ensure that every person is properly trained. Now, what is properly trained? Properly in whose view? Properly as far as reasonably practicable? No, that can't be the case. So this is a step backwards for both employer and employees. So we strongly oppose this proposed amendment. What is important is that a contravention of this section is, of course, an offense on the part of the employer. So one should allow at least a reasonable provision with some information as how a matter should be approached to an employer. Right, let's have a look at the next one. Now, Celeste, I think you deal with section 11.
Correct, Willem. I'm just going to get myself back onto the screen. So section 11 I mean, in a nutshell, everybody knows that Section 11 deals with the obligation to conduct risk assessments, and then it moved on to the obligation to prepare reports following incidents and accidents at the particular mine, which has always been a bit of a debate point in practice regarding the repercussions of such a report. But be that as it may, there seems to be, again, with respect, some confusion in the draft amendment bill as to the intention of the amendment. And also, of course, the purpose seems to be somewhat confusing as well. But essentially what they did was in Section 9 of the amendment bill, they start off by saying that they delete subsections 5, 5A, 5B, 6, 7, and 8, assumably of Section 11. And then they move on to Section 10, which says they then insert the following after Section 11 of the Principal Act. So that creates some confusion as to where exactly the intended insertion will be, what exactly is now removed, what is being replaced with the new amendment. And the confusion results in the proposed amendment actually being unenforceable due to the unclear nature of the proposed amendment. Obviously, the simpler approach would have been to propose the amendment as they've done with the rest of the amendment bill and just then say that they delete the following sections and substitute it with the following, which would have made it somewhat clearer, but I'm assuming that will then in due course be clarified. The proposed insertion of Section 11A of the amendment bill is really just a repetition of the existing sections, subject to one or two additional clarification insertions. So it's repetition. The same effect could have been achieved by just amending the existing sections, but be that as it may, the particular amendment that I want to just draw to everybody's attention is the insertion in Section 11A6. I don't know. There we go. Sorry, I'm just following where we are. So that is a definite improvement on the existing wording of the Act, because the employer now is responsible. The Act in its current format is that the employer is obligated to report to the principal inspector an accident occurrence that results in the illness of any person, and that has always been a criticism, because I mean that's flu for all intents and purposes. And I see there is now an improvement, and they've incorporated a serious illness. And the term serious illness is, of course, defined in the Mine Health and Safety Act, which will give employers some certainty as to what their reporting requirements are. And another, just in passing, another amendment to Section 11.5 with particular reference to the reports in terms of 11.5A of the Mine Health and Safety Act is now just specifically providing that employers have an obligation to submit the report within 30 days, but they can then talk to the principal inspector of mines and he can extend that time period or permit an extended time period if the same is requested by an employer. So in practice, this was in any event being applied, but it is now just being formalized and incorporated into the particular proposed amendments. So that is Section 11 of the Mine Health and Safety Act, and Willem will then continue with the proposed amendments to Sections 13 and 20.
Right, thank you. Before I deal with Section 13, let me tell you about the attack that we will launch against the proposed deletion of the words reasonably practicable in Section 10. Now, first of all, in my view, that contravenes and breaches the Mine Health and Safety Convention of the International Labour Organization, although that is not drafted very specifically dealing with particular matters. It says that employers shall take all necessary measures to eliminate or minimize the risks to safety and health in mines under their control. So all necessary measures are more strict and more restrictive measures, which are aims or measurements which are placed on the employer. So it is less of a duty on an employer to train by means of all necessary measures or to achieve all necessary measures of health and safety than it will be when the reasonable practicability measure is applied. So, and that convention was adopted by the government of South Africa on 9 June 2000. And in terms of the constitution, that must be adhered to in legislation. So that will be a breach of the legislation. And then in any event, we think a good argument can be made out that the deletion of the words reasonable, practicable, that will breach Section 22 of the Constitution, which gives a person the right to occupation and so forth. This infringement does not comply with the provisions of Section 36 of the Constitution. In terms of Section 36, it must be justifiable, and if it's not justifiable, then of course it will not be accepted. But I will not deal in great detail with that, just as a background. Now, if we deal with Section 13, being the question of the medical surveillance system and the occupational health practitioners, there's not much of a change. The change is about the qualifications of the person, the occupational health practitioner, and the bodies it must belong to, it must have a membership of. So that is no great concern. Let's have a look at the next slide. Now, this slide, section 13.4c, which is proposed to be added, says the following. An employer must ensure that the occupational medical practitioner issues a certificate of fitness for work for every medical examination conducted in terms of Section 2C. Now, at the moment, obligatory examinations must be performed in the beginning, the entrance examination, and then the exit examination. And certificates must be furnished, of course, after the entry examination of a certificate of fitness. In my view, it will be too onerous to require that certificate to be issued in respect of each and every medical examination. But I would like to hear what the audience, specifically medical practitioners, what their view is in this regard. So perhaps we can have comment at this point in time. Any person to comment? It seems to me that there's no concern. Hopefully people agree with me. But in my experience, not as a medical person, but as a lawyer, I think it's going to be too onerous to require that in respect of each and every medical examination. Bearing in mind that the words medical examination is not defined as an examination where you examine a person fully in order to determine whether the person is now fit for work in respect of all relevant aspects. It's any medical examination. So that goes too far. And so we will take instructions from our clients and then we'll adopt a sensible approach to this provision.
Willem, if I can just come in here, you will see on the chat group or the chat box, there's a comment there, practically very hard to achieve to issue a medical certificate for every examination. And then what does the subsection say? So maybe if you can just deal with those two issues that came out of the chat box.
It should be left to the employer to determine whether it is now, whether it is possible, reasonably possible, to issue that in respect of anything else apart from the entry and exit examination. And there it might differ from employer to employer. The one employer may employ a number of occupational medical practitioners, and they can really cope with it. Others may not be able to do that. I think that should, at the best, it should rather be dealt with in a code of practice. But employers, they can deal with that in their own standards and procedures. It should not be legislated.
Thank you, Willem.
Then slide, let me see, 13A1, yeah. Section 13A1 and 2, that deals with the procedure to be followed if a person is now declared unfit to perform work. There was a gap in the Act, and it wasn't clear to people, what the procedure is. So that those amendments I will not oppose. What is important, and it's not on the slide, you will remember in section, go to the next one. Section 12 to A, B, and C, again, no problem with that, deals with procedure. Perhaps the periods of 7 days to do certain things is too little, too short. Then one can have a look at that and maybe extend that, try to get it extended. Then what is important is subsection 22C, which says the employer must in the prescribed form and manner report to the medical inspector any dismissal by the employer of an employee on grounds of unfitness to perform work relating to disability, injury, or illness attributable to occupational cause. So that's something new, but I don't think that's a problem. At the moment, there is no prescribed form. The word prescribed is defined in section 102 as prescribed by regulation, and the word regulation is again defined as the regulations which are binding in terms of the Act, being those in Schedule 4 to the Act, and the regulations issued in terms of the Mine Health and Safety Act. Then, apart from this, there is one aspect which has not been mentioned by the department in this draft, and that is the question of the prohibition against the suspension from employment of an employee who is now dismissed on grounds of unfitness. Section 20(7), so subsection 7 says, an employee lodging an appeal under subsection 1 may not be dismissed on grounds relating to unfitness to perform work pending the outcome of the appeal. Now, that doesn't comply with the rule of law, because section 210 of the Labour Relations Act says that where a matter is dealt with in terms of the Labour Relations Act, then that act must be given preference to any other provision, similar provision in other legislation. So as far as section 210 is concerned, the Labour Relations Act applies when you deal with the dismissal of a person on the basis of unfitness. And unfitness is dealt with in section 188 of the Labour Relations Act, and that deals then with how you should deal with people who are dismissed, the procedure relevant to and the grounds for dismissal on those grounds. So that must be given preference, and the Department of the Minerals and Energy cannot now regulate that. That we raised previously in 2013. And I've also got quite a section on that in my book. But obviously, the department doesn't want to give preference to the legislation, which is not acceptable. So I think it is the appropriate time when employers draft representations to the draft bill to deal with this as well. If it's the appropriate time, deal with it, because a number of issues will now be debated and will be considered, so it's the appropriate time to do so. So that deals with section 20. That's fine, we've dealt with section 20. Then we get to section 42, to the membership of the Mine Health and Safety Council. Now, just as some background, the Leon Commission recommended way back in 1994-95 that something like the Mine Health and Safety Council with permanent representative bodies, being IMRAC, SIMRAC, and so forth. Then that was changed in 2008, and the word permanent was deleted. The question of permanence is important, because otherwise the Mine Health and Safety Council can every now and then change the membership of these bodies. And that's why it should be permanent, so that you can have continuity and people can really deal with the relevant matters they should be dealing with. So that is a concern. Then in 2008, it was changed to committees. And as I say, these committees, they can change the membership from time to time. And now there is an attempt to change the membership, because at present, the Mine Health and Safety Council have the following membership. There's 5 members representing employers, 5 members representing employees, 4 members representing the state, and then the chief inspector who must chair the council. Now the idea is that the state should have 5 members, as it's stated there in the second last line, representing employees, and then 5 persons representing the Department of State. So instead of 5 for employers, 5 for employees, and the departments of state being the Department of Mineral Resources and Energy, there should now be 5. And then in addition, there should then be the chairperson being the chief inspector of mines. Now, I think where we also find difficulty with that is, first of all, the control of the state together with the chief inspector of mines, together sometimes with the support of the representatives. It becomes difficult to deal with that situation if there is no consent on particular issues by the representatives for the employers. And further, I think there should be a neutral chairperson, and it should not be the chief inspector of mines. So on that basis, this will be changed. But you will also see that this is a pattern that runs through the amendment bill. The attempt by the department and then also by the minister to obtain more direct influence in decisions made in relating to health and safety. Many of the things which are at present being done by the chief inspector of mines will be done in future by the Minister or the Director General. Okay, let's have a look at the functions of the Mine Health and Safety Council. There, as you can see in section 43A of the amendment, at present, the council, one of the council's functions is to advise the Minister on health and safety at mines, including but not limited to any legislation on mine rehabilitation insofar as it concerns health and safety. So obviously, the department, they do not want the Mine Health and Safety Council to deal with mine rehabilitation concerning health and safety. And I think that is a very important issue. I read a report yesterday in one of the newspapers about a very large number of small coal mines which have been abandoned and which pose serious concern for health and safety. So we must keep the Mine Health and Safety Council directly involved also to deal with the mine rehabilitation concerning health and safety. So I don't think that is an acceptable proposal. Then, after section EA in 43, the following insertion is proposed. It says that the Mine Health and Safety Council must establish and control an administrative fine fund for the fines imposed in terms of section 55. Section 55 deals with the imposition of the administrative fines. That was the idea way back before the Mine Health and Safety Inspectorate was established, but then it never came off the ground. So this is now proposed, and so that all the fines will hopefully now go to the Mine Health and Safety Council. And then, subject to the approval of the Minister, fines collected must be used for the promotion of health and safety in the mining industry. And in the annual report, it must reflect the affairs of the fund. Right. Let's have a look now at the Mine Health and Safety Inspectorate. The Mine Health and Safety Inspectorate was established in terms of the 2008 amendment to the Mine Health and Safety Act. And that was established as a juristic person. That flows from the idea way back in the Leon Commission that there should be a body focusing specifically on health and safety. And then the idea was that that should be a juristic person, and that body should employ its own inspectors and personnel. And those should be people with expertise. And that there should be some separation between that body and the Department of Mineral Resources and Energy. Because there, you know, the Minister and the DG, they very often make decisions which are not really based on health and safety considerations, but are political decisions. So that was the idea, to rather give it to a body, a more expert body to deal with. But then when the Mine Health and Safety Inspectorate was established in 2008, this was never incorporated. It was never implemented. It was just on paper, there was a juristic person, but he didn't carry out any functions in practice. He didn't have his own assets, its own accounts, and so forth. So that is why it was now decided to delete the establishment of the Mine Health and Safety Council as a juristic person. But now the Act still says, if it's amended, that the Mine Health and Safety Inspectorate is hereby established, which is very strange. Now, how do you establish something? You establish it comprising of persons. The persons may either be a juristic person or persons, or natural persons, people. So the only inference is now that the Mine Health and Safety Inspectorate will now comprise of one or more persons. But the Act doesn't say how many persons. And I think on that basis, it can be attacked on the basis that it is vague, and in fact, it's void for vagueness, because that's a principle in terms of the rule of law, that law must be comprehensible and it must be able to be understood by the people. And one doesn't know whether the Mine Health and Safety Inspectorate is now one person or X number of persons. Then together with that, you would see that the Public Finance Management Act of 99, which applies at present to the Mine Health and Safety Inspectorate as a juristic person, that provision will also be deleted. Of course, if the Public Finance Management Act doesn't apply to one individual natural person on his or her own, it does apply, of course, there are certain functions for secretaries and so forth, company secretaries and so on. And so that is why it's sensible, it makes sense to delete it. But now, as a result of the fact that the Mine Health and Safety Inspectorate will now merely be a part of the department, the Public Finance Management Act applies to the department in any event. So it will still be applicable, but now only in the sense that the Mine Health and Safety Inspectorate are members then of the department, and the department must comply with the Public Finance Management Act. I hope that answers the question that was raised in this regard. Then we deal with Section 18A 3. It says that the following sections must be added to Section 47. There's a subsection 3. The minister must appoint an officer with prescribed qualifications and appropriate experience as principal inspectors of mines for each region contemplated in subsection 2. Then the minister must appoint an officer with prescribed qualifications and experience as a medical inspector, and then appoint officers with prescribed qualifications and appropriate experience as inspectors. Now, that seems to be innocent if you read it like this, but let's analyze this. Prescribed, the word prescribed is defined in Section 102 of the Mine Health and Safety Act as being prescribed by regulation. And the regulations are the regulations which are binding in terms of Schedule 4 and also regulations issued in terms of the Mine Health and Safety Act. Now, the only regulation that I know of that deals with the prescribed qualifications inspectors is Regulation 7.1 of the Mine Health and Safety Regulations, which was issued in 97, and that says the following: an officer must comply with the appointment requirements of the personnel administration standard for the occupational class inspector, mines, or the occupational class, inspector, mining machinery approved by the Public Service Commission, etc., etc. But then if you do a search, then you find that most, if not all, the provisions of the Public Service Act have been repealed. And now there are other provisions which apply. And there's no specific qualification in those mostly guidelines as to what the qualifications should be. So it seems to me there's a complete vacuum as far as this is concerned. And in fact, if I'm right on that, then it means that an inspector, including a principal inspector, including the medical inspector, cannot be appointed because there must be definite prescribed qualifications. And only when provisions are there and people comply with that, then of course those persons may be appointed. So this is a serious issue which we will look into and which I think is appropriate to raise at this point in time with the department when the amendments are considered. Let's see. Let's go to, just go back. Next one. Right. Now, what is of concern is also the proposed addition of section 47(6) as referred in 18B of the amendment bill, which says the following. To further the objectives of this act, the minister may enter into written agreements with competent persons and authorize such persons to perform any or all the functions of an inspector. Now, we know that an inspector has got wide, very extensive powers. The inspector may visit the mine whenever he or she wants to. The inspector may issue prohibition orders. The inspector may close certain sections of the mine, and very often they close the whole mine, and so forth and so forth. So very, very wide powers, a very powerful person. Now, in terms of this proposed provision, the minister may enter into written agreements with competent persons and authorize such persons to perform all those functions, any or all of the functions. This is of great concern. And the words competent persons, those words are not defined in section 102 of the Mine Health and Safety Act, nor are they defined in the amendment bill. So I would like to see who are these persons who are now considered by the minister, not by the chief inspector, as competent. Probably the minister will delegate those functions to the DG, but the DG is a political appointment. So we must oppose this provision. Then we will deal with section 48A and 49B, the Public Finance Management Act. As I said, although it will not apply in future to the Mine Health and Safety Inspectorate because it's no longer a juristic body, it will carry on to be applicable to the department, and the department must comply with it. I think, Celeste, we get to you with section 54. Is it 34? Let me just see. No, but we jump now. Section 96 belongs to the end. So, Celeste, do you want to deal now with section 54? Otherwise, I can deal with.
No, I think, Peter, Willem, I'm happy to continue with section 54,
Yeah.
and then we can link that section 96 into your discussion on the penalties and all the rest, and we can just link that slide in there. So section 54 is the great excitement in the mining industry generally, and it has the proposed amendment seeks to remove the words "has reason to believe" and to replace those words with the word "observes." Now, going back one, we must bear in mind that an inspector, in terms of 54, has a power to ultimately shut an operation or a particular section of an operation if the requirements of section 54(1) are met of the Act. So what this proposed amendment has done is ultimately to remove the objectivity question from the basis upon which an inspector has exercised a right in terms of section 54. So the words "has reason to believe" were originally inserted into the Act by the legislature in terms of the Mine Health and Safety Amendment Act 72 of 1997. And it was a very intentional insertion because the test to determine the reasonableness of this exercise was then objective. That means that a court of law would be able to consider all the facts and information that was before the inspector in order for him to then make the decision he did, in order to conclude that there is an occurrence, practice, or condition which endangers or may endanger the health and safety of persons. And in that manner, the court could then decide the reasonableness of the conclusion and ultimately then the subsequent instructions. Now, the insertion or the proposed insertion of the word observes has removed that objective element of the test and has changed it to a subjective test. And that's because the word observes has not been defined in terms of the Act. And in terms of our laws of interpretation, then, if a particular definition is not provided in a particular piece of legislation, one would then look at the ordinary dictionary meaning of this word. Now, the word observes means see, hear, perceive a particular condition. So observes in this context then is a subjective determination. And that then means that an inspector ultimately, as long as he can demonstrate his subjective belief or what he observed, would then be able to justify the decision ultimately taken, which is of a concern to the industry as a whole, because even though at the moment the 54s are reasonable, there have been in the past instances where a 54 has far-reaching repercussions and has ultimately resulted in the shuts of a whole mine, which has financial implications. So this proposed amendment would, in our view, result in a proliferation of appeals to the Chief Inspector of Mines relating to the closures, possibly additional urgent applications to the Labour Court to suspend the operation of the 54s. And it just opens the door for abuse of the particular section. And even though perhaps persons may have the best intention, it is not an objective intention and it is not based on reasonable facts. And one would have some difficulty in challenging those decisions in that circumstance. The other proposed amendments to Section 54 is just a practical suggestion. Sorry, Heather, I'm just looking at your question and I'm assuming it's now in context of my comments of 54. You said what would be better used. I'm assuming better used in terms of the word. And the answer to that is to keep it as is. The proposed amendment does not address practically what is the intention of Section 54 and has far-reaching repercussions. So the suggestion would be to oppose the proposed amendment in totality because it doesn't serve a objectionable purpose. And the words were very carefully selected in 2007 to achieve what the legislator wanted to achieve. Okay, thanks, Heather. Then the 54s, the instruction, once it's issued in writing, the Act previously provided that it must be confirmed by the Chief Inspector of Mines, but that was never happening in practice. In actual fact, I'm not even sure if it practically is confirmed, but they've now just proposed the amendment to say, well, let's rather than have it confirmed by the Principal Inspector of Mines, which in our view is reasonable and it makes sense. In any event, the Principal Inspector of Mines are the ones that hear the upliftment, and it would also, in our view, be more practical to deal with it in such manner because the Principal Inspectors are the ones that the companies in any event engage with on the issuing of such 54 instructions. Just waiting for the slides to move so we can all follow together, and there we go. Section 57(1), the proposed amendment there, now that is Section 57, in summation, is just the right to appeal a decision of an inspector to the chief inspector of mines, and all the proposed amendment is now to say that any person affected by a decision of an inspector or a decision by the principal inspector of mines may appeal the decision. The legislator and the drafter of the proposed amendments has lost sight of the fact that the word inspector is defined to include the principal inspector of mines. So the proposed insertion is superfluous and doesn't serve any purpose, as inspector is always interpreted to include the principal inspector in any event. And the prohibition against appealing an administrative fine decision has also remained in place. Now, that's a practical question in itself. And the reason why such an appeal would not be allowed to the chief inspector of mines has always been a questionable inclusion in the Mine Health and Safety Act. So companies may want to consider just approaching the mine health, the amenders, and just saying, look, if we're going to talk amending the act, perhaps we should consider this lack of appeal to the chief inspector of an administrative fine decision by the principal inspector of mines. It's a somewhat nonsensical exclusion. Then the next particular section that I just want to reference is the proposed insertion of section 57.4, that there is no problem with, in the sense of it is in any event confirming what the principles of administrative law require. And that requires that one exhaust your internal appeal process before approaching a court for any form of remedy. And all it's saying in this context in that you cannot approach the Labour Court to review any decision until you've exhausted the appeal process to the Chief Inspector of Mines. And we don't have any objection to that. It's a practical inclusion. And as I said, it just confirms in any event the principles relating to administrative law. And then the last proposed amendment I would just like to reference is this proposed amendment to section 59.2 of the Mine Health and Safety Act. And essentially what this proposed amendment is doing is, let me just be more specific, it's 59.2b, the proposed amendments to that section. Now, the existing provision entitles a party to apply to the Labour Court to suspend the operation of any decision pending the outcome of an appeal. What the proposed amendment has now done has incorporated the words of the Chief Inspector of Mines, which ultimately has resulted in individuals being prohibited from approaching the Labour Court to suspend the decision of, for example, a principal inspector of mines on an urgent basis based on the nature of the decision. I mean, you're not going to utilize that remedy in all circumstances, but, for example, a 54 instruction that shuts your whole mine, that remedy was important because you had access to the courts for an appropriate remedy. And what this is now requires is that you have to wait for the outcome of the decision by the Chief Inspector of Mines for an appeal. So that could take weeks, days, even if you request it urgently, there's no time period for such turnaround. So that severely limits parties' rights to access to the courts and to prompt judicial assistance and legal remedies. And we are of the view that we should again just oppose that insertion of the words to facilitate that parties are able to exercise their legal remedies in a fair manner. I just want to, I've finished the portion of the appeals and the 54 instructions. I just want to reference at some stage, Owen, you had a question regarding the changing of the words of body corporate to companies and whether that would have an impact on holding companies in a greater sphere. And my answer to that question is the word body corporate was never defined in the original act. And it's not if one looks at the sections in context, it very clearly intended to refer to a judicial body. And in our sort of context, that judicial body would be a company as defined in terms of the Companies Act, which is now the definition that is provided for the term company. So by removing the word body corporate, which is not a judicial person in the context of perhaps body corporate would be, for example, sectional title units that would be run by body corporate. The more appropriate legal term would be a company, which is now defined. And it's important to say that that company reference is limited to the employer being the company. So the employer is the holder of, in most instances, the holder of the mining right. So that would be the company that holds the mining right. So the practical application of that amendment would not change what is happening in practice, and no, it would not, in our view, result in greater exposure to outside entities that are not the holder of the mining rights and the actual employer who has the obligations in terms of the Mine Health and Safety Act. I hope that has answered your question, Owen. We can discuss further if need be at a later stage. So Willem, I'm finished with my portions unless there's any particular questions on that, and I'll hand back over to you to get to the exciting part, which is a great debate with the penalties and the corporate homicide. Thanks.
Yeah, but before I deal with that, I just want to mention, as far as the last issue dealt with by Celeste is concerned, the limitation of the employer in future in terms of the proposed amendments to only be able to approach the labor court in the event of an appeal to the labor court concerning the suspension of a decision of an inspector. That we will attack. And I think there is a good basis to attack it as being in breach of Section 34 of the Constitution. Section 34 says, everyone has the right to any dispute that can be of law decided in a fair and public hearing before a court or, where appropriate, another independent and impartial tribunal or forum. Now, as Celeste has mentioned, it can take ages for the Chief Inspector of Mines to make a decision on the appeal. So the matter starts off, the inspector issues a Section 54 order, closing the whole mine. You appeal immediately to the chief inspector. Now the chief inspector takes a lengthy period of time to resolve it. What do you do in the meanwhile? You must be able to stop the implementation of that order pending the final outcome of the appeal to the chief inspector. And I think that's where there is that is where there is a breach of the provisions of Section 34. And that reason, your right to refer to has been suspended for that period of time, which may be very unreasonable. Right, then I will deal with Section 86 and the proposed amendments to Section 86. Now, the existing Section 86, that was incorporated in the Act way back, 1997, with the first amendments to the 1996 Act. And that says the following: any person who by a negligent act or by a negligent omission causes serious injury or serious illness to a person at the mine commits an offense. This is similar to the provision that we've got in Section 37 of the Occupational Health and Safety Act, applicable to industries outside mining. And then further, any person other than an employer or employee who by a negligent act or by negligent omission endangers the health or safety of a person commits an offense. So here what we've got is, if there was a negligent act or omission and where it then causes harm, so there must be causation, then there can be an offense. We must keep in mind is applicable apart from the common law crime of culpable homicide. Culpable homicide is the unlawful, negligent killing of a person. And in other words, there are 5 elements. There's the conduct, which may either be an omission or an act, and it must be unlawful. So there must have been a breach of a duty of care, breach of statutory duty, etc. And then there must be a death, and then there must be causation, you see. But now the legislature thought that that is too easy and too difficult for the state to overcome the proof of those elements, which shouldn't be the case. Now in Section 86A, the following is proposed. Section 86A says, an employer commits an offence if the employer contravenes or fails to comply with the duty in terms of Chapter 2 of this Act. Now, we must keep in mind that the word employer is defined as the owner, and the owner is defined then as the holder of the mining right or permit, etc., etc. So it's the mining company, but it may also be a natural person. And so it will be offence for that person if that person contravenes or fails to comply with the duty in Chapter 2. Chapter 2 refers to a large number of sections of the Act, starting with Section 2, ending with, amongst others, Section 24. So in terms of Section 2, the employer must operate the mine as far as reasonably practicably, safely, and not hazardous to health, and so forth. Then Section 10 dealing with training, Section 5 read with Section 11 dealing with risk management, Section 12 with occupational hygiene, 13 with medical surveillance, and so forth and so forth. So a very large number of those obligations which are placed on the employer. A contravention of any of those provisions of the Act from 2 to 24, read with Section 91, constitute at present an offence of the Act. But now an additional offence is created in terms of 86A1, and that is if the employer now breaches any of those duties and it results in a person's death or serious illness or injury to a person, then it is an offence. So that is serious. So it's no longer, as if you read the section, required that there must be negligence on the part of the employer. Section 86A2 says, if a chief executive officer, manager, agent, or employee of the employer commits an offence by performing or omitting to perform an act, and such performance or omission would have constituted an offence had it been done by the employer, that employer is equally liable, committing an offence if the act or omission fell within the scope of authority or employment of the chief executive officer, etc., and so forth. In other words, if it's work-related, that is how I interpret the word scope of employment, then the conduct of the employee must be imposed on the employer. So there is vicarious liability. And that will be the case if the following is the situation. Bracket A, paragraph A, or subsection A. If employer, the agent, employee, etc., and the employer connived, a very strange word, connived with or permitted the act or omission by the chief inspector, the chief officer, chief executive officer, manager, agent, or employee concerned, or did not take all reasonable steps to prevent the act or omission. So if we stop reading Section 86A at subsection 2, then it would seem that if you as employer had taken all reasonable steps to prevent the act or omission, then you can escape liability. But it's not as simple as that, because let's have a look at the next slide. It says, for the purposes of subsection 2, the fact that the employer issued instructions prohibiting the act or omission is not in itself sufficient proof that all reasonable steps were taken to prevent the act or omission. So that's not the worst, because you can't just issue one instruction and then you assume that everything will run its normal course or the course that you expect it to be. But now it gets worse. because subsection 4 says the following. For the purposes of subsection 1, the fact that the employer issued instructions prohibiting the act or omission is not in itself sufficient proof that all reasonable steps were taken to prevent the act or omission, not a problem. But then subsection B, it's not a defense that the death of a person, injury, or illness was caused by the act or omission of an employee of the employer if the act or omission fell within the scope of authority or employment of the employee. Now, this is ridiculous because it draws a line right through causation. We know that 99% of accidents on mines occur as a result of human behavior. Very few accidents occur as a result of vis major, force majeure, act of God. And, you know, so the most of the accidents occur as a result of human behavior. And how does a corporate body, a juristic person like a mining company, how do they operate? They are artificial persons. You can't, the company can't walk, the company can't smell, it can't eat. It can only act through employees. So the chief executive officer will run the show of the company. The chief executive officer will have directors, managers, and so forth. A number of employees will be appointed to perform the acts of the company to ensure mine health and safety and so forth. Okay, now people do that. And some people do the job, some don't do it for some other reason. Then what happens now if an employee, remember, it doesn't need to refer to the employee whose conduct we're referring to in subsection 4. What happens now if the one employee, he doesn't give proper instructions in regard to the support of an underground stope, and now another employee dies as a result of that? Can you then say, but I'm not liable as employer or CEO and so forth, because we've got this health and safety management system. And in terms of that, we've got a whole structure of appointments, mine overseer, shift boss, miner, and so forth. And they must ensure that proper installation is installed, and so on and so on. And unfortunately, for some reason or other, the shift boss and the miner, they didn't do their job, and there was no proper support installed in the particular area. Now, you can't rely on that. Subsection B says, it's not a defense that the death of the person injured or the death or injury or illness was caused by the act or omission of an employee, any employee of the employer, if the act or omission fell within the scope of authority or employment. So if it's work-related, and it is work-related to install proper support. So you can't rely on that. So if you read now subsection 1 with subsection 4, then it actually draws a line through causation and then also, in my view, negligence. So it is a question of strict liability. And this is shocking. Now, this was raised before. This was raised in 2008 and again in 2013. In 2008, it was in fact in the Act. And I can read to you how the wording was at that stage. But then, as I say, employers with the cooperation of certain other parties got the president not to announce the promulgation, the commencement of that section 86A. Before, it says the following, and you will now see why it was not implemented. Defense of ignorance or mistake by any person accused cannot be admitted. Now, I don't know what that says. There's a serious problem with the grammar. And then it further says, defense that the death of a person, injury, illness, or endangerment was caused by the performance or an omission of an act falling within the scope of authority or employment of any individual within the employ of the employer may not be admitted. Again, I don't understand the words may not be admitted. So we opposed that section on the basis that it didn't comply with the rule of law. It was not drafted in a sense that it was comprehensible and intelligible, and one couldn't understand what was required of you. And then, as I say, by proclamation, the president then announced the commencement of the other sections, apart from this section and one other section, which is not relevant to the discussion. So how will we now oppose this? I think we can make out a case that it fails to comply with a number of provisions of sections of the Bill of Rights. Section 12, Section 22, Section 35, and that deals with the deprivation of property, the right to carry on an occupation or a trade or a profession. And so there's a basis to attack it. Then once we've done that, then of course, in a court of law, the department will have to show that the infringement of these rights are justifiable. So was it really necessary? If we look at Section 36 of the Constitution, it says the following. That defines the ambit, the scope of the limitation. It says the rights in the Bill of Rights may be limited only in terms of law of general application, which is the case here, it's general application, to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom, taking into account all relevant factors, including the following. 1, the nature of the right. Secondly, the importance of the purpose of the limitation. 3, the nature and extent of the limitation. 4, the relation between the limitation and its purpose. And then lastly, less restrictive means to achieve the purpose. I don't think it is necessary to implement this to control health and safety and improve health and safety. When we've got legislation, it must just be applied by competent people, not only at the instance of the department, but also at the instance of the prosecution, which doesn't really happen. It doesn't help just to create legislation and hope for the better. We don't need it. But where does this come from? I think it comes from the corporate manslaughter legislation in the UK. I'll tell you now what it says. Somehow I've lost my paper, but I'll find it now. It's not this one. In any event, whilst I'm looking for the legislation in England, the Corporate Manslaughter and Corporate Homicide Act of 2007, that applies to England, Wales, Northern Ireland, Scotland, and the provisions are primarily the following. It says that if an organization to which the section applies, and that you can substitute that now with the employer in our instance, if that organization is guilty of an offense, if the activities are managed or organized and they cause a person's death or they amount to a gross a gross breach of the relevant duty of care. So there, the element of that must be a gross breach. That is it's important before there will be a conviction, a breach of this provision. So it's not a question of only any breach. Any breach of any of the provisions of section 2 to 24, if that results in the death or serious injury or serious illness, then there is no offense. In terms of the English legislation, there must be a gross breach. And then further, there's a description of the relevant duty of care. And then as far as the penalties are concerned, there's a differentiation between the different offenses. So it's not as in the case here of section 86A that it applies to 86A together with the penalty clauses. That applies to everything and any obligation in terms of section 2 to 24. So this is it's overbroad, it's unnecessary, it's unfair, and this must be strenuously opposed by employers. So I think it's important that employers, they also draft, they don't rely only on their representative bodies, but they draft their own representations as well, in their own words. They don't need lawyers to do that. If they can, of course, it may be an improvement, but otherwise they must write to the department and send in the opposition to this very far-reaching and draconian provision. But let's have a look at the further relevant provisions, which also links up with section 86. Section 92, let's go back. Section 92 says the following at present. Any person convicted of an offense in terms of section 87 may be sentenced to a fine or to imprisonment to be determined by the court. And then subsection 2 and 3 deals with matters which are not relevant for the present discussion. And then section 4, subsection 4, any person convicted of an offense in terms of this act for which no penalty is otherwise expressly determined may be sentenced to a fine or to imprisonment for a period not exceeding 6 months. And then subsection 5, any person convicted of an offense in terms of any section mentioned in column 1 of table 1 of schedule 8 may be sentenced to a fine or to imprisonment for a period not exceeding the period mentioned in column 2 of that table. Let's have a look what, oh yes, and then there's also subsection 6 and 7 which exist at present. And subsection 6 says, an owner convicted of an offense in terms of section 86 or 86A may be sentenced to a withdrawal or suspension of a permit and B, a fine of 3 million rand or a period of imprisonment not exceeding 5 years or both. Now, of course, 86A doesn't exist at present. So that was a mistake in 2008 on the part of the drafter and the legislature to refer to section 86A. Then further, it was in any event also a problem to refer to the withdrawal or suspension of the permit, because the word permit is not defined in the Mine Health and Safety Act, and you cannot just assume that that refers to the exploration permit, the mining right or permit, and so forth. So it's section 92.6A is not enforceable at present, but 92.6B is enforceable at present. And then subsection 7 makes provision for a remedial type of order. Let's have a look what the legislature wants to do now, or the department wants to do now. Next one. Now it is proposed that subsections 1 to 5, that they all repealed. So subsection 6 and subsection 7 still remain, okay? So you can still have the argument about the suspension of a permit and so forth, and in 6. But it says the following. Any employer or a company convicted of an offense in terms of any section of this act may be sentenced to a fine not exceeding 10% of the employer's annual turnover in the preceding financial year, as reflected in the last available financial statements in the Republic, and the employer's exports from the Republic, whichever is greater, or to imprisonment determined by a competent court. Now, who can be fined and penalized like this? Any employer, so it's the employer, which is defined as the owner, and eventually is the holder of the mining right or permit, or a company. So in other words, even if the company is not an employer, the company can be fined to this extent for an offense in terms of any section of this act. Now, which section can be contravened by a company that is not an employer? That will be Section 86, and Section 86 refers in Section 86(1), as you would have seen, to any person. So any corporate body, any natural person. And then subsection 2, there and an employer or employee can contravene that. So the contractor company can still be nailed. In terms of Section 86(1) or 2, well, 1 and 2, read with the new proposed penalty provision in this section, Section 92. This is very far-reaching. I think the thinking comes from the Competitions Act, where in the event of conduct which is prohibited in terms of that, party is penalized for engaging in that restrictive practice and profiting from such practices. But this can't be the rationale in this case, because what do you want to achieve if you say now to a court that the maximum fine, not the minimum, the maximum fine is now 10% of the annual of the employer, or then the total exports from the Republic? Do you want to kill the company? Do you want to bring it to an end? Now, the argument, of course, I assume on the part of the department will be, but that is not a minimum. It's a maximum. Look, it will be worse if it was a minimum. But now, legislation gives an indication to the presiding person, whether it's the judge or the magistrate, how serious is a contravention, and then what penalty should be taken into account. So very often there's a maximum is set. But then you can't now say that all transgressions of the Mine Health and Safety Act are equally serious. So if you send in the 11.5 report to the Inspectorate, say 2 days late, then it is just as important and just as serious as the death of a person in an underground accident for which a person is held liable by virtue of his or her conduct. It is not the case. It can't be. There are certain offences which are more serious than others. This was recognized in England in the corporate manslaughter case, where there's a guideline applicable to offences, and where there are certain maxima which are recommended in the legislation. So guidelines in terms of that refers to a large organization which has a turnover of more than £50 million. And then there's a recommended maximum fine. Then there's a reference to a medium organization where the turnover is between 10 and 50 million pound sterling, and then a small organization and a micro organization. So that makes it more fair, at least, even if one accepts now the principles behind Section 86A as proposed. But as I said, in any event, it should only, if it is enacted, it should only refer to something similar to the English legislation of a gross breach. and not to any breach. It is absolutely unfair and ridiculous. And as I say, that can be attacked in terms of many sections of the Constitution. Let's have a look. And we must keep in mind, of course, apart from this, Section 91, that remains. So Section 91 says the following. Section 91 says, any person, including an employer, who contravenes or fails to comply with any provision of this Act, regulation, etc., commits an offence. And then the penalty is prescribed in Schedule 8. And Schedule 8 was introduced in 2008, and it increased penalties severely. And I don't think the argument can be, but it hasn't worked. Then if it hasn't worked, then it's not due to the employer. But as we have seen, there's more and more a movement to criminalization of mine health and safety. And it will become more and more important to deal with these issues in a preventative fashion, try to avoid accidents, try to avoid any breaches. But it will send a very serious message, especially the penalty provisions read with Section 86A, to the investors. It will tell investors, don't invest further. If you invest, you take a huge risk that you and your people may be charged with a contravention of Section 86, and that you may be penalized to that extent. Penalty only to the company or to the employer body. And it will also tell people who wants to invest here, these are the risks you run if you come to this country. So this is a disincentive to investment in the country. This is a disincentive to employ people, because if you've got people, you may have persons who may be killed or injured, or they may be diseased. And you want to avoid that. So people will try more and more to mechanize. And I assume that what may also happen is that areas which are more risky to mine, you will rather not mine those areas. So you may restrict mining to more safe situations, although you can deal with those difficult situations if you apply a proper risk management procedure. So this is not positive to our economy. This is not positive to the creation of employment for employees. It's a sorry state of affairs, and we must oppose this very, very strenuously. Right, any questions on this? I think there was a question from Heather. What was your question, Heather?
Willem, if you look at it, Heather made a comment there. When inspector is used here, it does not include the DMR, environmental inspector. Is this correct? If you can just comment on that. And then also Karusha just asked if you can just address the change in the definition of mining area.
Yeah, the first, Heather's question, I agree with the question. It doesn't apply to the environmental people. This applies only to inspectors in terms of the Mine Health and Safety Act. Then as far as the definition is concerned, there was I read through it. I didn't think it's important to deal with it in this presentation, but a rewording of it. But at the end of the day, it goes back to the old definition. If I can just get the particular provision in section 102. Sorry, what's the question about mining area?
Question is, kindly address the change in the definition of mining area.
I think it's a rewording of the words mining area as defined in the MPRDA. But of course, you will see that it doesn't refer to old order rights. But I think perhaps that is now something of the past. I don't know. perhaps there will still be some of those areas which will be regulated in terms of their order rights status, although it's unlikely. But otherwise, I don't think it's a serious or it's a real amendment to the existing provisions. Because in terms of the definition of a mine and the mining area, the reference must be made to the MPRDA. Anything else? Nothing on section 86A. Right. Then we can deal with the next topic. So let's see. Right. We go to the next one. Right, section 55B. Celeste, I don't know whether you're going to deal with that. Let me just see. Otherwise, I can deal with it. Let's see.
Willem, I'm happy just to...
Oh, no, that's fine. I see that we decided that I will deal with it. Now, section 55B says now that the Principal Inspector of Mines may impose a fine not exceeding the maximum amount mentioned in Table 2 of Schedule 8. But now, the problem with the drafter is that they said that Schedule 8 must be deleted. And Section 8 deals not only with fines, but also with the admin fines. So now if the amendment is accepted, then the situation will be that the Principal Inspector of Mines may impose an administrative fine referred to in terms of a schedule which has been repealed and which has no validity in law. In other words, it's not enforceable. But I assume that was an oversight with the drafting of the amendment bill. Next one. Then section 93. Section 93 of the Mine Health and Safety Act provides at present as follows. Magistrates Court has jurisdiction to impose penalties despite anything to the contrary contained in any other law. A magistrates court has jurisdiction to impose any penalty provided for in this act. Not a problem, that's clear. Now there's a proposed amendment to that section, and the word magistrates is deleted, and it says now a competent court has jurisdiction to impose penalties. And irrespective of what you think about the word competent, that means in law, in this case, it can refer to any court. So it can refer to a magistrates court, a regional court, and a high court. And they have jurisdiction to impose penalties. And it says, despite anything to the contrary contained in any other law, a competent court has jurisdiction to impose any penalty provided for in this act. And that will include then section 86A, the new 10% laws. Now, what is the jurisdictional scope of these courts? At present, the High Court has got unlimited jurisdiction as far as the extent of the penalty is concerned, the amount. So they can impose a fine of 10% of turnover. But if the matter is heard before a regional court, then the limit is 600,000 rand. Imprisonment of 15 years, if it's an individual person, a natural person, because a company can't be jailed. And then if it's a magistrate's court, it is 120,000 rand or 3 years imprisonment or both. So that will be the restriction. So even if Section 86A is implemented, then if there are criminal proceedings and they institute it in the magistrate's court, then there is this jurisdictional limitation, 120,000 rand and or 3 years imprisonment. Regional court, 600,000 rand and or 15 years. So if the department, with cooperation of the the National Prosecuting Authority, they want to nail a particular person, company, or the employer, then they will have to do it in the High Court. And I don't think that the High Court will be able to handle many of these cases. There's a lack of personnel at the moment, a huge workload that the people have got. So in practice, it will be very difficult to implement it. So I think the legislature and the department will rather, with the NPA, should rather go the usual route to refer the matter to a magistrate's court, unless it's a very serious matter, and then refer it to the regional court. Right, next slide. Now, I referred in the beginning to the line that runs through the Amendment Act, also read with previous amendments and attempted amendments of the more departmental control of mine health and safety through the Director General and the Minister. Now, this you will also see in Section 96, 1 to 4. Section 96 is proposed to be amended by inserting the words Director General now in subsection 1. So subsection 1, as amended, as the department would like it, will refer to the following. The Minister may delegate any power conferred upon the Minister by or under this Act, except the power of making regulations to the Director General or Chief Inspector of Mines. Up to now, the delegation must be to the Chief Inspector, and now it will only go to either him or the Director General. The Chief Inspector of Mines is appointed as a result of his experience and expertise in mining, and is not a pure, or hopefully not a pure political appointee, which is not the case with the Director General. So this is of serious concern, that there is an attempt by the Minister to exercise more departmental control in respect of health and safety, and not to leave it to somebody with expertise in that department, somebody like the Chief Inspector of Mines. Then subsection 2 is proposed to be amended to read as follows. The Director General or the Chief Inspector may delegate any power or assign the performance of any duty conferred upon the Director General or Chief Inspector by or under this Act or any other law to any inspector, be any other person with appropriate knowledge and experience who's under the control of the Director General or the Chief Inspector of Mines. So here again, there creeps in this concept of a so-called competent person or a person with appropriate knowledge and experience. What experience? What knowledge? So this is a serious concern. We must, the application of the Act through inspectors and through people carrying out similar functions as inspectors, should be left to competent people and people with specific qualifications. Otherwise, we're going to have absurd decisions and conduct which is not objective and not fair and reasonable. In subsection 3, again, the insertion there of the Director General, and then 4, a delegation under 1 and 2 does not prevent the exercise of the power by the Minister, Director General, or Chief Inspector of Mines, as the case may be. And then subsection 5 is added, which reads as follows. The Minister, Director General, or Chief Inspector may at any time withdraw a delegation or assignment and withdraw or amend any decision by a person exercising the power or performing a delegated duty or duty assigned. So that I've got no difficulty with. And I think that is the end of my presentation. Yeah, thank you. If there are any questions, then I will try to deal with them. And so I call upon all of you to try and draft the representations opposing these amendments, or the important ones that I mentioned. Doesn't matter if you don't put it in legalese, set it out in your own words. And specifically Section 86A, read with the penalty provisions. That's a very serious concern. With the deletion of the words reasonably practicable in Section 8, referring to training, that we opposed previously with success. Those words were initially inserted in the Act right in the beginning, and I think we will win at least that one, that the department should accept that the deletion of those words will have consequences which they haven't thought of, and that should rather remain. Thank you for all your participation in the presentation. Unfortunately, it's not as direct as seminars have been in the past. And so hopefully most of you are still listening. I cannot, of course, judge that. But thanks for your participation, and go well.
Just from my side, thank you, everybody. Thank you, Willem. It's always interesting and informative to hear the views about all of this. And thank you for joining. And if there's any questions to ourselves, please don't hesitate to contact us, that we can assist. Thank you.
Willem and Celeste, thank you very much for these very informative presentations and also for the discussions. And then also to all the attendees, thank you very much for attending. We will make available the actual presentation, the slideshow presentation. It will be emailed to all of you. And then a recording has been made of this session, and that will be loaded onto YouTube. Feel free to contact us if there's any further queries. Stay healthy and be safe, and then also enjoy the rest of your day. Thank you very much.